Good evening, everyone present here. Tausif this side. Our esteemed guest speaker has joined us in the session right now. So it's our great pleasure to welcome you all to our 10-day online capacity development program. I am thrilled to introduce our esteemed guest speaker for today's session. It's our honor to have Dr. Raj Kumar Sandhu sir. Dr. Raj Kumar Sandhu sir has been working as an assistant professor in the Department of Law, University of Jammu since 2011. Sir has done his PhD in law from Jammu University, and his area of specialization are corporate and business laws. So, as we move forward with our program, we are excited to learn from Dr. Raj Kumar Sandhu sir's expertise and insights on the topic of changing contours of dispute resolution in India. So, on behalf of our entire team, I would like to extend a warm and heartfelt welcome to Dr. Raj Kumar Sandhu sir. Sir, we are delighted and excited to have you with us today and are looking forward to an engaging and informative session. So, without wasting further time, it's now our pleasure to hand over the session to Dr. Raj Kumar Sandhu sir. Sir, over to you.
Good evening, everyone. My name is Dr. Raj, and I am from University of Jammu. I am thankful to Kashmir Law College, Pro Bono India, and Mr. Yahya Ibrahim for the invitation. And I'll be talking about the changing contours of dispute resolution in India. Let me try to share my slide. If someone can help me, how to share it?
So, there is an
I'm not able
option.
to find the link how to share it.
There is an option. Share screen.
Entire screen.
Share
Yes,
share screen.
uh, let me see if it is visible to you.
Yes, sir. It is visible.
But I think multiple slides are visible. Or slide is visible to you.
Yeah. Yes, sir. The particular slide. I think it's slide number one.
Slide one, number one is showing
Yes.
where name is written.
Yes, sir. Yes, sir.
Okay. Now, second slide is visible.
Yes, sir. Introduction part.
Okay. So let me start with the lecture. So I opted the topic that how dispute resolution system is changing with the changing of time in India. So first of all, we need to understand that disputes are inevitable. Disputes are bound to happen, and uh, it is important for us to understand that how to settle these disputes. And if we are not able to settle the dispute, that it will create problems for the society. For just and peaceful society, settlement of dispute is very important, and we have seen that in recent past there is a transformation in the Indian legal system, and we are shifting from the traditional litigation based dispute resolution method to the new methods of dispute settlement, along with maintaining and improving the traditional dispute settlement system. So if we whatever system which we are having right now, it is based on our colonial past. Our courts and our law legal system is influenced by British legal system and their process of delivering justice. Even this what this court system, give me a minute. Even this court system is part of the process of colonizing the India. So whatever we got it from the Britishers, it was designed in a mechanism to uh, subjugate Indians. Further, we got independence in 1947, and we realized that being a poor country or country with less resources, if we want to invest heavily in judiciary, then our resources will be diverted from other necessary or immediate uses. So we shifted to panchayat systems. So it was the old system of settlement of dispute in India, which was prevalent prior to the Britishers. So it was given importance in the 60s, 70s, and 80s. You will find that a lot of focus was on panchayats. Even we got Legal Services Act 1987, which gave statutory recognition to the panchayats. Then focus shifted to ADR. We enacted Arbitration and Conciliation Act 1996, which was uh, improvement from 1940 Act, which was primarily based on unisettled model law. Then in 2023, we enacted Mediation Act, which significantly amended many other laws, and we shifted to non-adversarial settlement of dispute system. Then, as we have discussed that, I hope next slide is also visible. Hello.
Yes, sir. Yes, sir. Slide number three.
So we, yes, so we shifted our focus towards alternate ADR system. ADR is a gamut of methods where we can use negotiation, mediation, conciliation, arbitration, and other hybrid methods of settlement of dispute. Primarily, their focus is on settlement of dispute and out of court settlement of dispute. And these methods are very flexible and comparatively less informal than traditional litigation based dispute settlement mechanism. Now there is a new age concept which is developing in India, that is ODR. ODR basically stands for online dispute resolution, and in case of ODR, we integrate online ICT tools. ICT tool here means information and communication technology, which include and not limited to video conferencing, emails, or or using other methods where parties, judges, mediators, or advocates, they interact through a digital mechanism. And this method is very accessible, less expensive, and more convenient for dispute resolution. So in a country like India, where we have a huge population and access to justice is a big problem. So in this country, in such country, ODR can be very useful. So ODR in India is a new phenomena. We have seen recent progress in India after COVID-19. We shifted that entire uh, education judicial system to online methods. Still, online proceedings are going on in India even after after COVID. So basically, COVID accelerated the process of digitalization in dispute resolution. So in case of ODR, it is not the supplementary to the traditional system. It is also complementary to the traditional system. We can integrate ODR into the traditional form of dispute settlement. We have seen during COVID-19 that how we shifted our court system to the online hearing, and there are other methods in wherein some part of ODR is integrated into traditional system that we will discuss in the later part of our presentation. So as we have discussed, it's a efficient, convenient, cost-effective mechanism for settlement of dispute, and ODR is also fast method, because many things which we can do, we need not to do manually. We can do it through algorithms, through softwares. Say for example, if two people are submitting a dispute, so we can easily find what are the similarities and what are the differences. So these things can be done through the use of AI, algorithms, and other forms of digital or other digital tools. So if we want to trace the history of ODR, so internet was established in the year 1970. World Wide Web started in 1989. Internet was opened for commercial purposes in 1992. First article in a law journal on ODR published in 1996, which talked about that how we can use technology for settlement of disputes. So first step which was taken for ODR was in 1996 in USA, where two courts were established: virtual magistrate, that was basically an online ombuds office in University of Massachusetts, and there is a family dispute ODR project in University of Maryland. So these they were the first pilot projects which were used, which were done to experiment that how we can use technology for settlement of dispute. With the emergence of e-commerce, ODR got a very huge boost. So first project which was launched by e-commerce entity was by eBay in 1999. They hired a third party which was Square Trade, and Square Trade is able to was able to solve approximately 200 disputes in a 2 weeks time. So realizing the importance and the effectiveness of effectiveness ODR, eBay included ODR as an option for settlement of dispute. So by 2010, eBay was able to solve 60 million disputes through ODR. Now, even if we all buy products from e-commerce entities, and whenever we have a problem, we lodge our complaint, and that complaint was is settled through a online mechanism. Sometimes we are interacting with a chatbot, or sometimes chatbot transfers our complaint to the person which is on the other end. So many steps are done through a computer based process, like uh, what problem you are facing, which order problem you are facing, like it, whether it's a relating to payment, it is defective good, change of goods, many things is done by online mechanism. Then later on it was done through human intervention. So similar developments were done in Canada, which established online small claims dispute under Canadian Civil Resolution Tribunal. Then development happened in China, Gendong Arbitration Commission. They also started online arbitration for e-commerce disputes. Then China is the country which worked on AI and how to use AI into settlement of dispute. Now, coming to the what is the legal and regulatory framework in India for online dispute resolution. So, still our legal framework is developing. We do not have any unified law dealing with online dispute resolution. So, we can trace provision into different laws. So, first and foremost law is the IT Act. IT Act basically provides a legal framework for information and communication technology based transaction in India. Then, whenever there is a, if you want to settle a dispute through ODR, there need to be a contract between the parties. So, Indian Contract Act come into play. Then, if we are going for a settlement, so Arbitration and Conciliation Act will also come into play. Many disputes are settled in consumer protection through the process of online. I'll be discussing in the later part of presentation that how uh, uh, we are able to integrate ODR into Consumer Protection Act very effectively. Then, since it is online based, data protection is very important aspect. So, Digital Data Personal Data Protection Act 2023, and there is a rule frame, information technology reasonable security practice procedure and sensitive personal data of or information rules of 2011, which was framed under IT Act. They are also irrelevant. Then Evidence Act, because many things are done electronically, and now it is replaced by a new act, BSA. So it will also come into play. Then there is a act, Mediation Act 2023, which is again important for the purpose of ODR. So these are the main laws which are applicable if you want to locate a legal and regulatory framework in India. But still, we don't have any specific law dealing with the ODR. Now, coming to the what are the benefits of online dispute resolution? First and foremost benefit is the it provide access to justice, and it also increase the accessibility. So still we know that the access to justice is a big problem in India. Many people are not able to get the justice, or not able to approach the justice, or even courtroom mechanism is not favorable. It is it is affected by a lot of delays, a lot of cost is involved into it, and common people, they are not, even if they have resources, they are not willing to approach court for the settlement of dispute. So access of justice, it will improve. Next is that it's a cost effective, that many costs are reduced because you'll not be requiring any physical movement, physical documents. Everything can be done online. Even for hearing, there is no need to physically travel. So it is a very cost effective method. It increases the convenience that you can do it from your home. You can, like, if we are having this lecture, so I am sitting in Jammu and I am delivering lecture to you, so through online process, so it's very convenient, easy. There is no need to travel. Then it's again a time saving, because if you move from one place to other place, it will include cost and time. Even for advocates, if they want to move from one court to other court, it will take a lot of time. So if they are sitting in their chamber, they can provide their services through one place. It increased the efficiency because many things are digitalized, many artificial intelligence softwares, algorithms are used, so it increases the efficiency. Even notice summons, they can be delivered through the online process. It is environmentally sustainable because less paper is used, less environment pollution is created. The system is neutral because technology is there. It is very difficult to influence technology. You can always bribe or influence individual, you can have approach, but in case of technology, it maintains the neutrality. Then further, it also leads to preservation of relationship, because when parties are physically present, there is a possibility that their ego may clash. It may they may not be able to uh, discuss or talk properly, but through the process of technology, when they are not sitting face to face, it is easier for them to come to terms for settlement. Again, the entire process, because it creates a digital footprint, and digitally we can monitor everything, so it increases the transparency. We can have record of every proceeding, what said, what are not, what is not said, everything is recorded, so it increases the transparency. We can have access of entire proceeding anytime we want to have. Again, we have discussed the what are the benefits, and it also contains certain challenges. Um Challenges include that there is no legal framework for India. We can locate into different laws, but still there is no specific law dealing with ODR in India. Then still there is a digital divide. There are people who are digitally educated, and there are people who are digitally not literate. Even like places like J&K, we have seen that in past there are a lot of internet outrage, internet cuts. We, I think, for a year and a half we face internet blackout. So if we move into digital space, we are not sure that we will get uh, the connectivity throughout the year, or even if we have seen that not all areas having the equal connectivity. So in urban areas we have a better connectivity, but in rural and remote areas there is a connectivity issues. So first, that people are not aware, they are digital literate, plus, and there is a problem for access to the technology. Moreover, this there are concern about the impartiality and reliability of ODR system, because in India or globally there are private ODR platforms for settlement of dispute, and they are government owned. So if there are private parties involved into it, so there are issues on the impartiality and reliability. Then uh, uh, we are aware about technical issues. Then if connectivity, internet issues, and they can be proved to be counter effective. Then there is lack of awareness in India. Very less research is done on ODR in India. Very few articles are written on it, and still work is under process. Lack of awareness is there. People are not even aware that ODR is still happening. I'll be sharing certain examples where ODR success stories of ODR in India in the later part of the presentation. Now coming to ADR, we know that there are methods for settlement of dispute, including negotiation, arbitration, mediation, conciliation, and other methods, which is alternate to the traditional form of dispute resolution. And this method is less formal, less rigid, and more cooperative, and more non-adversarial in nature. And there is a possibility of having a win-win solution out of ADR. In case of a traditional form of dispute, one party wins, another loses. But in case of ADR, there is a possibility, because there is a settlement between the parties, so they can have a win-win situation. Now, how to integrate ODR and ADR into traditional formal system? So the ODR and ADR is not in competition with the traditional formal system. Rather, it can be combined together. So we can create a hybrid mode where we can have ODR along with ADR and traditional formal system. So we can use ODR into ADR. We can also use ODR and traditional form of dispute resolution through the litigation. So many things can be done through video conferencing, online chat, or through online filing of documents. So we can integrate the system, and system will become more effective. And the main challenge in this process is to maintain the fairness, that both parties should have equal access. Then, if we integrate ADR and ODR into the dispute settlement system, so it will increase the accessibility, convenience of the parties, and even parties are, if they are located at different geographical locations, they can easily interact through the use of technology. So it reduces the travel time. It becomes more cost effective. Even administrative expenses of maintaining records is also reduced through the process. And if many things are done through the online process, so it the entire process become faster. So dispute can be settled, streamlined in a faster way. It also increases transparency in documentation in dispute resolution, because entire proceeding, entire record can be digitally stored. Now, coming to the, we have discussed in the previous slides that I'll be discussing about ODR in consumer dispute. So, in the new Consumer Act, which was enacted in 2019, which is now applicable in India, in first time it talked about all mediation in consumer dispute. So again, yes, slide is visible. Any question?
No, no, sir.
So I'm discussing that how we can integrate ODR into consumer dispute. So in Consumer Dispute Act, Section 34 is there, which talks about settlement of dispute through mediation. Further, Mediation Act amended Consumer Protection Act. So if there is any mediation proceeding under Consumer Protection Act, it will be governed by Mediation Act. So in Mediation Act, there is a provision for online mediation also. So it means that we can have online mediation in case of a consumer dispute. So it's a new step if in Consumer Dispute Act. Then there is a Consumer Dispute Residential Commission Rules 2020. In this rule, there is a provision for e-filing, e-summoning, and e-payment of fee. So they again integrating the technology into it. Even now, recently, I think few weeks back, there is a rule is amended, and e-hearing, online hearing is also added into it. And then we have a e-commerce rules of 2020. E-commerce rule of 2020 says that if there is a e-commerce dispute, it has to be settled through the online method. So there is a mandate on e-commerce entity to provide ODR on their on their platform. So that is again one part. Then there is a draft e-commerce policy regarding consumer protection through online dispute resolution. This policy again advocates that e-commerce disputes are best suitable for settlement through the online system. Then Niti Aayog is taking lead into it, and they have already issued a document which underlines the importance of ODR in settlement of dispute, because still in India more than I think 4.5 crore cases are pending. More than 4 crore cases are pending, and if we are not able to solve this dispute effectively, it will have impact on our growth, or that delivery of better services to public. Then, what is the relationship between ADR and ODR? Then, both methods are similar to each other, because they focus on dispute resolution. Both method can be used for outside courtroom settlement, and the only difference between ADR and ODR is that ODR primarily focus on use of internet and ICT technologies, and in case of ODR and ADR, because it is done with the consent of parties, so parties they have a significant say in the dispute resolution process. So it is very convenient when parties are situated at a different place. They need not to come to one place for hearing or for settlement dispute. The method is transparent and efficient. Now we'll come to the how this method is used in India. So it's a we have already discussed that it's a relatively a new concept, and looking at our size and population, it is almost a continent. So it will be very useful when if we integrate ODR into resolution process. So it can be used very effectively in e-commerce, banking, and insurance and healthcare sector, because they are more suitable. We can easily integrate into them. Then we already have a very good digital system where we have online transaction, online payments, and we can similar way we can also provide ODR services. Then government has taken a lot of initiative for ODR. These projects are e-code. I will discussing in detail. So these are next slide is relating to the success stories. So in India, we started 20 years back. So we adopted a national policy and action plan for implementation of information and communication technology in Indian judiciary. So it's a government of India was proactive. They started in 2004 to create a policy for implementation of ICT technology in Indian judiciary. So one of other project is 2016 National School Bangalore. They established online conciliation and mediation center. It was later on taken over or funded by Ministry of Consumer Affairs. In this case, if there is a dispute relating to e-commerce, it can be settled through online mediation. So in this system, parties they can file a complaint, and there is a nominal fee of 100 rupees. And then one complaint is filed, it will go to the e-commerce entity. E-commerce entity will submit their response, and then system will give parties to settle themselves. And if they are not able to settle, then it will go to a third party mediator who will propose the resolution. So through this process, many disputes are settled, and it is very effective that you need not to go to even consumer court for settlement of dispute. Then in 2017, Government of India in MSME sector, they launched a Samadhan portal that if any MSME is having any dispute, they can e-file and they can go for online settlement if the dispute is against any public sector entity, government ministry, department, or even state government. So Samadhan portal is provided to MSME to settle their disputes. Then in Supreme Court took initiative to establish E committee, and this committee is supervising the integration of information technology into judicial system. They have already done a lot of things that on the website we can find case status, we can find orders, we can log on to get other information also. We can search on the basis of party's name, on many other information is available. Then there is a e-court system, which is the mechanism for tracking of cases, payment of fee, service of notice. Then Government of India, they have a national e-governance service delivery gateway. In this gateway, it is basically integration of various government department and services, so that there will be seamless transaction between the government, different departments of the government. Then we have a draft national e-commerce policy, which was launched in 2019, and it was issued by DPIT. And it basically suggests that if there are grievances, it has to be settled through the online system of dispute settlement. In 2020, Reserve Bank of India, they issued a guidelines where they asked the banks to provide online dispute resolution to the bank if there are banking disputes between the customer and the bank. So at present, banks are also providing online ombudsman and other facilities if there are customers having any problem. Then in income tax department, they started e-assessment, faceless assessment, and there are e-challan system through the module developed by Ministry of Road Transport and Highways. In Jammu, recently on 10th of June, this e-challan system integrated traffic management system was launched, and the entire system, the entire traffic violation challan system is online right now. It was done under Jammu Smart City project. So I hope that similar provision is also there in Srinagar. Then there are certain private centers and bodies which are also working for dispute settlement. Recently, if you are watching Shark Tank India, there was a ODR guys who got funding from them also. They wanted to. There was a private ODR system. So many ODR systems are India where they provide advice. They help parties to negotiate. They help party to settle their dispute, or different type of facilities are provided. So I have listed few of them, and there are even more than whatever I've listed. Now that how we can ease the court process through ODR. So we have seen that nowadays there are e-filing is going on. You can file cases either manually or physically or through online also. So it is very convenient. Next is that if there are objections, it is provided to the parties through online means. So algorithms are used to identify objections, and they are communicated to the party. That case numbering and case allocation is also going digital. So it is very convenient for the party. Otherwise, we have to wait manually, working hours, there are holidays. But now, if technology is there, everything is done seamlessly. Service of summons, notice, they are done through the online process, and which is again a very secure process. Again, conferencing, video hearing proceedings are undertaken by video conferencing. Earlier, if you want to bring any criminal to the court, a lot of security is required. But nowadays, it is done through video conferencing, where there is a less burden of on the security forces also. Further, that we have seen that even Supreme Court of India is live telecasting court proceedings. We can access through YouTube. In many states, recording of court proceeding is going on. In Punjab, there is a pilot project going on where two districts are opted, and entire court proceedings are recorded digitally. So again, it is creating efficiency in the system. Then, in conclusion, I want to say that there is a need for recognition of online dispute in India in a better way. Then we need a national plan for online dispute resolution, because we understand that it will create a lot of benefits, and the entire process will streamline. It will be convenient. Then more research and development are required in ODR system. We need to create more fair, transfer, and better system for dispute resolution. We need to have an infrastructure. We need to integrate IT professionals into our judicial system. Already some efforts are done, but more efforts are required. Then mobile app can be created through which people can get information about ODR very easily. There is a need for investment in infrastructure and IT tools, and we need to teach our judicial, clerical, and other staff on IT, because even all staff is not digitally literate. Then there is a need to integrate government departments so that they can access government documents easily wherever and as per dispute it is required. Then we need to bring ODR into our teaching subjects. So at LLB, LLM level, along with ADR, along with mediation, we also need to teach our students about ODR. In Jammu University, we have one topic in our ADR paper relating to ODR. So people should get some awareness about it. Then we need to make mandatory ODR in certain category of dispute. It can be used for consumer dispute, which is related to e-commerce, monetary dispute. We have already discussed that health disputes or health dispute related to healthcare, dispute related to e-commerce. They can be integrated into ODR system. So that's all for the presentation. I'll be happy to answer if you have any question.
So, any student having any question or
Do you have
questions, you may ask that. You can even post your question in the chat box as well.
But if it's a new area, if you want to write an article on it, then even it is a very good it's a good opportunity. I'll be presenting one article on this in the next month. I'll be going to Taiwan, where my paper is selected. So I'll be talking about that, how India is integrating ODR into our judicial system. So any one of you, you can also opt for it. Even you can have LLM PhD research on it.
Sir, has this online dispute resolution got any statutory recognition in India?
We have discussed that success stories in India. Like in case of Consumer Protection Act, there is a specific provision for settlement of dispute through mediation. Mediation Act says that there can be online mediation also. So there are acts in which there is a policy. E-commerce policy says that if there is a consumer dispute, it has to be settled through the ODR mechanism. So in scattered way, there are acts in India which talks about settlement of dispute through ODR. And then we have discussed that there is a Samadhan portal. There is a RBI guidelines for banks to settle dispute through online. So still it is under development, but and some government sectors, areas, departments, they have taken initiative to incorporate ODR into the dispute settlement mechanism. I thank the organizers for the opportunity. It was a very pleasant experience for me. I'm thankful to the Kashmir Law College and Mr. Yahya Ibrahim, Pro Bono India, for providing this opportunity to me.
Thank you so much, sir, for an outstanding presentation, and we are deeply appreciative of the time you took to share your expertise with us. Thank you so much, sir.
I'll share the slides with the Yahya Ibrahim, and he'll be sharing with the participants.
Yes, sir. Yes, sir. Thank you, sir.
Sure, sure, sir.
So my email ID is on the slide. If you have any question, you can ask me on email.
Sure, sir.
Okay, sir. Okay.
Thank you. Thanks a
Thank,
lot.
thank
Thank
you,
you.
sir.